So did everybody get the email and the materials to download?
Yes.
Everybody has that?
Yes.
And
Yes.
we're combination here with the live class, which I've got twice as many in here as I had a few minutes ago because somebody else showed up. Hey. And then those of you who are on the Zoom. So this is our first double duty here. So be patient with me as we work through it. But it'll sure give you a great opportunity to ask a lot of questions and go through the process and learn some good things. So does anybody not have material? Of course, I have it on the screen. I'm sharing it on the screen, so you'll have it there. Does everybody have the material either here on the screen, or does anybody not have it as we talk about it and see what we're dealing with here? This is kind of a precursor to a class that I'm going to expand to a 3-hour class and have CCAR send it to TREC, because in your new renewal requirements starting in 2021, in your 18 hours of CE, you will have to have 3 hours of that 18 being focused on contracts. And so this will become part of that 3 hours that you'll be able to make use of. So this is a 2-hour, what we'll do today, and I'll expand on it. So you're kind of getting a preview of this class that you would be able to take in your next renewal to fulfill the 3 hours of contracts requirement as you work through that. So we're feeling pretty good about that. Okay, so the first parts of, on this first page where I talk about the concepts and the overview of, can I minimize that a little bit? Or, okay. So in the first few paragraphs on page 1 and deal with the concepts, and you know, this is theoretically kind of a basic class, although as I mentioned in my email, it's not something that experienced agents don't need to know. And I talk about the thing that when I interact with other brokers around the state, other trainers and people, the constant issue that comes up is agents being familiar with the concepts of the contract. When I talk about this a lot of my classes, we don't want to memorize. So are they giving me those screens when I'm looking through here?
No, they're just seeing your Zoom.
Okay,
They're
so
the only ones seeing here.
you're the, okay. So I don't have to look at this
Well,
for them to see me.
for them to see you, yes.
So for them to see me, I look at this?
Mm-hmm.
Okay,
Because this is still your camera.
okay. So the key is, and I talk about this in classes, is that you don't need to memorize the contract, but you need to understand the concepts. And in this class, we're going to talk about 10 of the concepts of the 1 to 4 family residential contract, the one we use most often, plus all 6 of the TREC contracts all flow from this one contract form. They all have 24 paragraphs. They all have the same concept. The difference from one contract form to the other is primarily the difference in the property, such as unimproved property contract. You won't have any reference to the seller's disclosure because you don't have that for land. In the condominium contract, you won't have any reference to a survey because you don't have that in a condominium. So the differences, the challenges we have as we work through that are going to be based on the type of property. So once you have an understanding of the 1 to 4 family contract form, frankly, you've got the concepts of all 6, with one little bit of an exception, the farm and ranch contract. That's the most complex of all the TREC contracts. It's the most detailed. It's got many areas in it that are very unique to just farms and ranches. And so while it still has 24 paragraphs and a lot of the same concepts, has a seller's disclosure and all those things, it's got a lot of other notices and things in it, particularly in paragraph 6, that are unique to farms and ranches. Back in the good old days when I started in business out in Abilene, there's a tendency for us to do everything. You know, we did a little commercial, a little residential, farms and ranches, that kind of thing. And I did all that. But in today's world, I wouldn't do a farm and ranch. Too complex, too many things going on. I'd refer it out to somebody who's really familiar with the concepts of farm and ranches. And so I would, you know, it's just, it truly is a different world. And when you really spend time looking at the farm and ranch contract, you really do get a sense of, you know, that's the key and how that works. One of the concepts that when I say we, brokers in the business, trainers, people that we talk about, we understand the concept that agents aren't familiar with the whole contract. They tend to be familiar with those things that to do on a regular basis and that come up. So when you have something that comes up in a particular transaction, it makes you aware of that particular item. I'm not talking here about, you know, some of those kinds of things, you know, that we talk about the basics that we deal with. Things that you just automatically are going to be aware of, you know, parties and price and properties and things like that. You should deal with it on a regular basis. The challenge is there are 9 paragraphs in the contract that have no blanks, no boxes, no choices. So people tend to ignore them, but they're very important parts of the contract. And we got some information here with some fun facts on how many paragraphs and subparagraphs, and blanks and boxes and all that kind of stuff, which kind of is just something for, it's information you're not ever going to share. You're not going to say to your client how lucky you are to be working with me. I can tell you about how many contracts we've got, how many paragraphs. I can tell you about subparagraphs. I can tell you about the number of blanks and boxes. And they're sitting going, next? Who do we have next to come in? Because, you know, we don't care. And they don't. And they shouldn't. They care that you know. But what it does is the more you know about those types of things, the more confident you feel about your understanding how this works. And that confidence comes across to your client as you work through that. So I would really encourage you to see all these kinds of things, just a little bit of an overview, that type of thing. One of the things that happens is when you look at this, for example, where you've got how many paragraphs, how many subparagraphs, how many subparagraphs, blanks and boxes, you begin to get a sense of this is just not a couple of pages. This is complex. There's a lot to it. And all the things that are there impact on the clients, impact on the transaction. And it helps you have a little bit more of a respect. You know, people sometimes give me a hard time about my focus on contracts, but I'm so focused on contracts that I understand what it does to everybody in the transaction. And I have great respect for what people are doing in a contract form and how they're coming to an agreement. And I really try to convey that to my agents and to people and help them understand here's what's going on. Where did I get down to where it shows participants and all that stuff? Numbers, I guess that's usually down the bottom, but I don't see one of those. Anyway, okay. It usually be up in where have participants, how many we've got. Okay, so let's look at the 10 topics. Any questions so far about what I've talked about here? Just because these are things you've got in your documents, a good reference for you to look at, understand the concepts. What? And so we've got the 10 topics, and I have 22. Okay. I have them cleverly numbered 1 through 10. It took me a while to work that out, but I think it's pretty good. So number 1, and you would expect this to be the number 1, and that's the parties. And we look at how we address the parties in the contract, and you know, clearly parties are defined in paragraph 1. And when we say parties, there are only 2 parties. There's a seller and a buyer. You may have 10 people. You may have 10 brothers and sisters who inherited the property and are all sellers. So you may have 10 people. You may have to go to an exhibit to list out all the 10. But seller is a term that you only have one seller, one buyer, regardless of how many people is included in that seller and that buyer, because that's a defined term. I talk about in this that we further address this in paragraphs 9B1 and 9B2. You've got a copy of the contract there, the contract form, because what 9B1 does is it talks about how the seller is going to convey title, and the contract, it references they're going to convey title in the general warranty deed. And 9B2 is how the buyer is going to buy by bringing good funds except for the escrow agent. And so we see that further reference of performances of the parties and how that's further addressed in the contract. And the key here is in the contract, we define the parties, we understand who the parties are, and what you need to understand is what the contract form, the contract these two parties have come to an agreement on, what they're doing is they are establishing some requirements. And once we have a contract, it's really important to understand, once the buyer and the seller have executed a contract, they've agreed to certain performances. The seller has agreed to do certain things. The buyer's agreed to do certain things. The seller has agreed to certain contingencies the buyer has, prove out the condition of the property and value and title and all that. And the buyer has agreed that they were going to do certain things. This is all from that day one in the contract. And neither party can be required to do anything they haven't agreed to in the contract. To change that requires a mutual agreement and an amendment to the contract after it's executed. So the rights and responsibilities are established at the very beginning, and that can't change except with mutual agreement of both parties. Neither party can unilaterally change those terms because the parties to the contract identified in paragraph 1, and that's everybody we're talking about. Going through the situation. So questions on the parties as we start out, because we're dealing with the overview concept. In another class, we get into paragraph 1 and all the variables for the seller, you know, our ideal situation, and we have it easily 80% of the time. The sellers are who's listed on the tax roll. Those are people who own it. It's their homestead. That's who shows up in paragraph 1. You got all the variables. You have a trust, you have an executor, you have an estate, you know, you have a corporation, you have an entity. All these variables that we talk about, we go into detail in paragraph 1. But the concept of it is what we talk about right here. So hard to sift through the shield. So any questions from the Peanut Gallery Zoom on the thing there? As we finish looking up paragraph 1 and what we're dealing with there, and what you as an agent need to understand what's happening when we define the parties and throughout the contract establish obligations of the parties. And we're going to see as we get into some of the other topics, we're going to see how we get into other challenges and other things that the parties are doing, particularly some of the contingencies and the due diligence that the buyer has in a couple of different areas. One, condition of property, and the other is title. And we'll see that addressed in another part of the topics. So I give you time to unmute yourself if you've got any comments or questions on this so far as we're dealing with this overview concept here. Okay. So number 2. We deal with number 2, it's the property. Now, the late David Fair, attorney, he was one of the attorneys on the very first broker lawyer committee that Trek had way back when, founder and president of Extra Fair Title Company. He since passed away and we greatly miss him. And he used to do a class and he talked about a contract and what if the parties just decided to sit down and draw one up? You know, what would they include and what would they not include? And he actually used as an example, what if the seller was selling an antique, very expensive antique watch, and the buyer was going to buy this antique watch? Well, they would agree to certain kinds of things. They'd agree to who's going to sell and who's going to buy. They would define the property. They would really have probably a very detailed description of this antique watch, what it was, maybe pictures of it, maybe some reference to it. They talk about things like the price. The seller might think up and say, well, I like you, sound serious. I can't say, but I'd kind of like you to put up a deposit or something to show you're serious about this, so I don't run off and sell to some other people. Well, that's our earnest money. That's that kind of thing. So all the things that we talk about are things that most of the time buyers and sellers say, yeah, if I'm going to enter a contract and sell something, here's some of the kind of things we talk about. And that's why these contract forms are really written in a good logical manner with, for the most part, except for a couple paragraphs, clear and understandable language. A couple of paragraphs have too much legalese in them that the attorneys had too much influence. But other than that, it's really pretty good. I thought that when I was on the Broker-Lawyer Committee, but it is what it is. So in number two, the property. I talked about the fact that number one, we reference to the property in paragraph 1. Because in paragraph 1, notice that we talk about seller going to sell and buyer's going to buy the property defined below. Well, happens to be the very next sentence in paragraph 2. Land improvements accessory referred to as the property. It could be anywhere, when it says defined below, it could be anywhere in the contract, all the way to paragraph 24. Happens to be the next paragraph. Because defined below means from that point to the end of the contract. And so here we talk about it. And so we actually reference it in paragraph 1 and we define it in paragraph 2. And there are a couple of concepts go on. When we get into a more detailed class and we talk more length about paragraph 2 and get into more about what's in 2B and 2C and all those things, we get into very detail. But the concept is, number one, everything the seller owns is conveyed in the sale, unless he excludes it. He has to exclude it in the contract. So unless he excludes it in the contract, everything the seller owns gets conveyed. And in paragraph 2, where we define it, we list out all those things. It's very important that an agent have a sense of what's going on. I talk about, for example, in the thing here, I've got where I talk about what's important in paragraph 2B and 2C and 2D. And part of it is, as an agent, you need to have an understanding of what's in those paragraphs. We're going through a little bit of a challenge right now with another company in that the listing agent and the seller had some comments in MLS about certain items are negotiable. And the seller thought, well, the buyer didn't say anything about wanting those items, so I must be able to take them. Well, but he didn't exclude them in the contract. And the listing agent and the seller are saying, well, but it's in MLS, so that counts. Well, it doesn't count. And we need to understand what counts and what doesn't count. And all that counts is what's in the contract. And so the parties understand. So the buyers and sellers aren't going to read 2B and 2C until a problem occurs. They say, wait, they took the curtains, which is what it was in this case. They took the curtains. Are the curtains on the list? Well, your understanding of it, you look and say, yeah, paragraph 2C, right there, curtains and rods, blinds, window shades, draperies and rods. It's all right there. And when all those items owned by the seller are automatically conveyed in the sale unless the seller does something in 2D. So unless the seller excludes it. Now, sometimes there's too much to go in 2D. You can go to an exhibit. Seller is including a whole ton of things. And there's no limitation. As long as it doesn't affect the structural integrity of the property, seller can exclude anything. I mean, literally anything. So, but you need to have an understanding of what's going on in that paragraph 2, because your client's not going to read it until a problem hits. So you want to deal with that. One of your jobs, unfortunately, you remember that class we had on how to read the mind of your client? Yeah. Mind reading 101? Okay. That's going to be important because you need to have a sense of what's important to a buyer, or they expect to get, what's important to a seller, or they expect to be able to take. We need to understand what they're going so that the agents can make sure it shows up in the contract. Because if there's a problem later, while we're not a party to the contract, if a track complaint hits and the party say, well, we trusted our agent and they didn't say anything, we could be found negligent. So we need to really look at that and think about what our clients are thinking about and see what they want to do as they kind of work through that. Does that make a certain amount of sense why you need to have a sense of paragraph 2B, 2C, and 2D? Yeah. Now, further under the category of property, we find ourselves talking about paragraph 7. And paragraph 7 is an incredibly important paragraph. Driving nuts. You say it's not a driving spot. Okay, fine. I understand. All of paragraph 7, 7A through 7H on the next page, deals with a property condition issue. It deals with in the very beginning of it, very beginning of 7. It talks about the access to the property. What we're really talking about in 7 is the due diligence for the buyer. Because one of the jobs of the buyer, let's see, they got your contract when they're looking at it's good, okay. So one of the things for the buyer, when the buyer agrees to pay $300,000 or $400,000 for the property, it's kind of implied, but it's actually stated in the contract. The buyer gets to prove up that the condition of the property is sufficient for it to be worth that $400,000. I want to make sure things are working. I want to make sure conditions there. I want to have the ability to go through that due diligence. 7A tells us how they go through that process, deal with that. 7B talks about the seller's disclosure notice that the seller give to a buyer saying, hey, here's what I know about the property as you work through that. We talk about in 7C under dealing with 7B and talking about the property dealing with the seller's the lead-based paint addendum if it's probably built prior to 1978, and we also in 7D deal with the as-is provision. Now our contracts are in fact as-is contracts in Texas. This means that once we have a contract, seller can't be required to fix anything. Now the deal may go away. It may be something the buyer during the option period does their inspections and the buyer says, if you don't fix this, I'm out of here. Well, they get to do that if they've got that right under the option or some other right of termination. They don't get to terminate just because the seller doesn't agree to do something. So the deal may go away, but the seller cannot be required to repair anything. Can't make him do anything. And that's what as-is means. Now, sometimes a seller will say, okay, I kind of semi-understand that because, buyer, when they made the offer, checked off D1, buyer accept property as is without really having a clue what that is. Buyer's agent just said, oh yeah, we always check that. The reality is you do always check that unless you have something specific that you're going to have in 72, specific repairs or treatments, something specific. And most of the time you don't have because you don't know much about the property. You haven't done inspections yet. You don't really know anything. Sometimes the seller will say, okay, I kind of semi-understand the as-is concept, but I want the buyer to know it really, really as is. I'm not going to do anything. I want the buyer to know that up front. And so sometimes you'll have a seller in special provision say, I want it stated in special provisions that seller will not agree at this price. I'm not going to do any repairs, period. Now, it may become a lender required repair. The deal may go away because we talk about lender required repairs in 7E. But the seller says, yeah, that's the deal. Now, it's not a terrible thing to do because occasionally buyers will fuss when the buyer goes out and spends money, option and inspections, and sends a repairman over and seller says, no. I said, wow, I'd really like to have known that was your attitude before we enter the contract and spend all this money. So sometimes it's a courtesy for the seller to say to the buyer, you get to inspect your heart's content. You can do all these things to your heart's content. But the reality is, it is as is, and seller can take that additional step. And it's certainly not wrong or illegal. And by the way, it does not affect on any level the buyer's right to do inspections, nor the buyer's rights to go ahead and send an amendment over and request repairs. Buyer can still do that. In fact, not just during the option period, but all the way to closing. A buyer can say, hey, I'd really like you to do this or that, and continue to negotiate. And they can do that. But seller doesn't have to do anything, but buyer can certainly ask. Because sometimes, as we move further in the transaction, and the seller's kind of gotten invested in this contract and this closing and this money coming in a couple of weeks. And so when some little something comes up, he says, okay, yeah, if I don't do it for them, I got to do it for everybody else. So, okay, fine. To get this deal, I'll do it. And so sometimes things change, and that's okay. Everybody has that right to do an amendment and to do some changes and work through that. But it's important for the agents to be very familiar with all things that are going on in paragraph 7 property condition. And one of the areas that we've begun to have problems, in fact, we're going through a little bit of a battle right now, deals with an AC repair issue, and it deals with paragraph 7F. And 7F tells the buyer and seller that if we're going to do some repairs, here's what the seller's got to do. If there's a license required for it, it's got to use a licensed person. In our example, they didn't use a licensed AC person, and as a result, the home warranty company had denied the claim, and we're trying to work through that. But the seller didn't understand. Here's what you got to do. Here's what you agreed to do in 7F. You agreed to, either it was licensed. There are a whole lot of repairs that can be made that there's no license required, but it has to be someone who that's their business. And by the way, a handyman fits in that category. Handyman who does that kind of sheetrock stuff and things like that, fixing the stairs, whatever, that fits in that category. That's kind of his business. So that would be allowed. What they try to avoid is the seller doing it on their own. They don't want the seller doing this stuff on the cheap. The only exception, and it has to be agreed to by both parties, it may be an AC issue and the seller owns an AC company. And this AC company, so I said, my company has maintained this property over the last 10 years, and my company is going to do this, which kind of means it's me, the seller, but my company is licensed, so we're good. But the parties need to understand that that's what they're dealing with. And so anything we good with the property condition? Because that's a very big due diligence of the buyer. The number one lawsuit in real estate is the buyer suing the seller after closing for either something the seller did not disclose or misrepresented about the condition of the property. So the due diligence of the buyer is very important. And with that, it's very important for the seller to be very transparent and make full disclosures to take away the situation where the buyer could, say, well, you didn't let me do this or that. We don't ever want to have our seller deny an inspection of the buyer. Let them inspect their heart's content. Track inspector, HVAC inspector, plumber, electrician, roofer, whoever they want. Now make it reasonable. If you got somebody occupying the property, you got to try to work as many as you can. So at some point in time, the seller said, every day this week, you've had somebody else come out. Well, you know what? It's not reasonable anymore. That's it. Now it's bad for the seller and bad for the buyer, but you have to be able to work through that. So you really need to understand what's going on with that very important due diligence. We'll find ourselves talking about another due diligence a couple of topics down when we deal with the entitlement. Okay, so number 3, price to include the financing. This is a really key concept that we need to understand what's actually in the contract, and including, because you've got the third-party financing addendum in part of your packet there, what's in the contract and what's in third-party financing and what's not. And you need to have an understanding as you work through all this what the parties have agreed to do. Because in paragraph 3, which that first paragraph we reference is, this is easy to understand. At one level, seller agrees to sell the property at a certain price. Buyer agrees to buy at a certain price. It's paragraph 3C. And the buyer also agrees to bring good funds as accepted with escrow agent 9B2. But we have challenges here that the seller may be concerned with where these good funds are coming from. The buyer says, well, I'll pay you $400,000 for your property. Seller says, well, where are you getting the money? I said, well, I've got $80,000, so I can put 20% down. And if I can find someone who'll loan me $320,000, I'll buy your property. Well, that gets into paragraph 3A and 3B and a third-party financing addendum. And this becomes important information for the seller, particularly in multiple offer, in which they're going to choose one over the other because of the financing. Our advanced class later this month, I'm going to spend probably about half of the class on multiple offers. And we're going to talk about all the things that are going on out there with multiple offers. But the seller's making a decision. Now, here's the problem. What really counts in paragraph 3 is 3C. 3A and 3B are really information. And the buyer can change 3A and 3B. You know, buyer can say, okay, yeah, I've got 80,000 and I'm going to borrow 320. And this or says, you know what? My lender has talked to me. The bank company used to talk to me. They said, are you crazy using your cash? We can give you a 10% down loan at, 3.25%, great interest rate. Why would you spend cash? You can use cash for other things. I said, well, we're going to do some things to the house. That's a good idea. Well, the buyer can change that 20% to 10%. He can change 20% to 5%. He can do that. And as long as it doesn't affect the terms of the contract, closing date, for example, as long as the seller does not incur any additional costs. Remember, at closing, it's all cash to the seller anyway. How the buyer comes up with that cash is not important from the contract, including third-party financing. It's information. And we talk in a class where we talk more specifically about third-party financing. We talk about the circumstances in which you might change from conventional to VA or conventional to whatever else. And we talk about how that works. But this is really important information, and it's one of our jobs as agents to really stay on top of. I keep looking to my people in the class. I don't want to be ignoring my Zoom people, so hopefully you're hearing me okay, and we can work through that, and don't throw anything at me. Okay, good. Yeah, Brian's is not his real picture, but if I had his real picture up there, I'd be friends. So Bob, would you forget about us? Okay, fine. Work through that.
Great job, Bob.
Yes. What?
You're doing a great job.
Oh yeah, I need to scroll down. Okay, yeah, let me get down to class including financing.
And Lori said you're doing a great job.
Well, thank you, Lori. Appreciate that. Okay, so to my scrolling here.
And then Bob, somebody asked in the group chat, does the handyman have to be does he have to have a license?
No, not unless he's going to take on something that requires a license, such as electrical or plumbing. But for example, roof repairs doesn't require a license in Texas. Working on sheetrock, your pull down stairs for your attic, things like that, to repair those. What is really strongly suggested in the in paragraph 7F, which talks about the repairs, that it be a business he's regularly involved in. So the seller can't say, well, I'm a really handy guy. I fix a lot of things around my house, so I think I'll do this. He's going to have to get permission from the buyer to do that. Just being a handy guy around the house doesn't help him do this. Okay, where's my? Okay, so right here. Okay, so let me get down to the thing we're talking about now, price including financing. Now we get to number 4 as you work through it. So in dealing with the financing, notice nowhere in the contract and nowhere in the third-party financing addendum do we name the lender. And one of our challenges lately has been buyers changing lenders. And what happens often is if that's done too late in the contract, it can affect closing. It can affect the terms of the contract, and that's not acceptable. But seller needs to understand we've agreed to something that's not in there. Now, there's nothing that keeps a seller, particularly a seller who's had the bad experience before, from saying to their agent and saying, you know what, I know this is going to be attorney prepared language, but the seller says, I want the buyer, I'm going to accept their offer, I want the buyer to identify the lender. I want that pre-approval letter from the lender as part of the contract. And I want the buyer to agree that they will not change lenders without approval of the seller. That'll be attorney prepared language. That way the seller has got the buyer locked in and says, you know what, you need to understand, I'm making a commitment to you. House off the market for, 3 or 4 weeks, expecting you to do it. And here are the terms that you're promising me. You're a great borrower and this is a great lender. And my agent has talked to the lender and everything's looking good. And we don't find ourselves the last week of the deal, you flipping off and changing something like that. Seller gets to do that. Now, it's got to be the seller's idea. We don't want to advise the seller to do that because we're practicing the law doing that. So we need to kind of work through that process. Does that make semi good sense? Kind of? Okay. So topic number 4, this is kind of that good faith thing, that earnest money issue. And one of the things we understand about earnest money, when you look at the 5 essential elements of a contract, earnest money is not one of them. What is one of them is consideration. Consideration is the exchange of promise of something of value of the seller and buyer, which frankly is paragraph 1 and paragraph 9B1 and 9B2. Seller promised to sell, buyer promised to buy, and here's how they're going to buy and sell. That's really the consideration. There's nothing that keeps the 2 parties from agreeing to a contract with 0 earnest money. That's okay. Now you're still going to name a title company in paragraph 5 because we need to know where it's going to close. But there's not required to be. Earnest money is really treated as a good faith deposit. Buyer says, I know you're going to take your house off the market, although you have a right to continue to show it, except backups, you have a right to do that. It's in paragraph 19 of the contract. But I want to be sure that you understand that I'm serious about this, and I'll put up $5,000 showing I'm serious about it. Now, if they do agree on an earnest money in paragraph 5, and we're dealing with item number 4 here, and I've got in the handout there on page 4, that there are promises of the buyer and promises of the seller. And paragraph 5 sets that up. And there are risks to both parties. So the promise of the buyer, if they put a dollar amount in that first blank in paragraph 5, the promise of the buyer good nutrition. As the buyer is going to deliver that kind of earnest money, but in the paragraph 5, we've got a timeline. They used to have it, but we do have it now. It's a good thing to have. And buyer needs to understand they've got this time frame to get this money to the escrow agent. And if they don't do it, the seller has certain rights. And the timeline is 3 days. And there's a language in there that if the 3rd day falls on a weekend or a legal holiday, it goes to the next day that's not a weekend or legal holiday. But you get to that 3rd day just by counting calendar days. So if you have a contract that's a contract effective date on a Thursday, Friday, Saturday, Sunday is that 3rd day. We're going to go to Monday unless Monday's a holiday. But you got to that 3rd day just counting calendar days. So if a buyer doesn't do it in that time frame, do you have a question? Yes.
For the earnest money, if you're still within that 3-day period and the buyer decides to terminate the contract, then the earnest money is not a requirement if he's terminating the contract.
Okay, so Zoom class, the question Christy brought up, is that you're in that 3-day time frame, buyer has not delivered the earnest money, and through some other provision of the contract, maybe option or whatever, the buyer's going to terminate. So is there any obligation to deliver? From a practice standpoint, number one, no. In fact, our advice to our buyer is don't go through the process of delivering it and then have to fight the battle over getting refunded. Because the penalty to the buyer if they don't deliver it, the seller, after that 3 days is up, can terminate the contract. Well, the buyer's already terminated, so there's no point. So at that point now, if the buyer is terminating under the option provision, they need to pay the option fee before they do that. But we would advise them, don't put any earnest money in the title.
I had emailed you and Marcia this week. We had buyers that executed a contract the very next morning at 9. We had the inspector come out. They found cracked raptors, 3 of them, and all kinds of.
So they wanted out of the deal.
And so they wanted out. We had not yet delivered, and I picked them up at the house, in fact, for
You had not delivered what?
any funds.
Option?
Or.
Well, if you're going to terminate under the option provision, and that's an important distinction. So she's got a situation, buyer's inspected, now buyer wants to terminate, but money hasn't been delivered, no earnest money, fee, as I just mentioned. But if they're going to terminate under that provision, the option provision, they've got to pay the option fee. Now, there may be other rights of termination, such as, but I wouldn't go to the third-party financing. That's, while it's certainly a right, if you've got anything else like an HOA, okay, seller's disclosure, if you don't have a seller's disclosure.
We had a seller's disclosure. And
What was in the contract in 7B? Was 7B1 checked off where a buyer has the seller's disclosure?
Yes.
Okay, so they don't have anything there.
We had the seller's disclosure. What we found when
Yeah, things that the seller didn't disclose.
he did not
Yeah,
disclose
and so
foundation issues with
I think the simple scenario in that situation, since you have to fight some battles, and if the seller fights this battle, you're not going to sue them. You're not going to go to court over it. Go ahead and spend the option fee, terminate that provision, nice and clean, and move on. And just don't pay any earnest money. You guys are able to hear any of that on the Zoom thing and see the scenario? I don't want to totally miss you guys here and helping with my live class. And I absolutely respect people's decision. Say, I'm not ready for live classes yet. I understand that. I'm feeling very rejected, but so other than that, it's not a problem. I'm married, have 3 children, 6 grandchildren. I can handle rejection. It's not a problem.
Hey, Bob.
Yo.
Brian DeLuca, if you could just walk through best practice steps for that scenario. You don't have to run through everything, but just.
Yeah, okay. Best practice scenarios. When you have a buyer who very early in the transaction has had a change of heart, maybe new information, maybe just change the situation, and they're going to terminate. And it's 2 or 3 days into the deal. Well, first of all, the earnest money issue, best practice is, if you're going to terminate, don't do anything with the earnest money. Don't take it to the title company. We don't go through that battle of somebody else in control of the release earnest money. So leave that alone. But if you're going to terminate early on, the buyer has to look at what their rights of termination are. And what can they do here? If it's a Mancho HOA, they almost certainly don't have that information yet, so that's an easy termination. The buyer approval financing may be the case. May even be a property approval if there's some issues that come out in the inspection. The easiest is going to be the option. The second easiest is going to be the HOA. Third easiest is going to be seller's disclosure if 7B2 is checked off in the contract, so the buyer doesn't have it. They've automatically got a 7-day free option period. And one of the concepts, and you're going to have people on the other side who haven't been to our classes don't understand this. If your buyer has another good right of termination, such as Mancho HOA, and they haven't paid the earnest money, we already know why not to do that, and they're not terminated under paragraph 23, they're going to terminate under Mancho HOA. No reason to pay the option fee because they're not using that provision. The only time you're going to pay an option fee is if you're going to use paragraph 23. Because if you don't pay that money in the language in paragraph 23, if the buyer doesn't pay that money, he just does not have that unrestricted right to terminate paragraph 23. That's the only thing that's affected. Doesn't affect any of the rest of the contract. So a buyer who has other good rights of termination in those circumstances, wouldn't pay the option fee or the earnest money, would terminate on one of the other 9 provisions in the correct promulgating those termination contracts. Does that make sense? We kind of good with that, Brian?
Perfect. Thanks, Bob.
Okay, good. So the earnest money and the risk to both parties, by the way, with the earnest money issue, we're seeing this a lot. We're seeing this when contracts don't close and there's a battle of the earnest money, and there shouldn't be. The contract clearly says buyer gets earnest money, or clearly says seller gets earnest money. But the reality is, the policy of the title company, if they have a dispute here, that money's not going anywhere. And so there's a risk to both parties. When the buyer puts that money, that $5,000 to the title company, there's a risk they may not get it back simply because of what the title company is going to require. Like he says, I got to have everybody signed off on this, and still say, well, I'm not signing. Then you've got a battle. So there is a risk as you work through there.
Is that risk, does that risk exist because the title companies are under Texas Department of Insurance rather than CREP?
Well, part of it is. The question was, is that risk there because title companies are under TDI rather than under TREC, and they are under TDI. TREC has nothing with title companies. And they are required to be a neutral third party. But it's not really so much a requirement from TDI, it's the policy of the title company. Title company says they're very risk averse. They don't want to have risk of people filing claims. And so they say, if we incorrectly give the buyer the earnest money, and the seller says, they shouldn't get the earnest money. They didn't have any right to terminate. Why are you giving them the earnest money? You think you give it to them because you like them, or you do a lot of business with them, or that's your brother-in-law, or whatever. Then the title company is faced a risk of a title claim, of a claim in the transaction. So the safe thing for most title companies, we don't have full agreement, that's the deal. Now, we had one with the seller recently where the seller wanted to deal with the earnest money issue. In fact, they were okay with giving the earnest money back to the buyer, but they didn't want to give up the right for future action against the buyer. They may want to sue the buyer. They may feel like they had damages or something. Well, if you use the Texas Realtor release earnest money form, it releases everybody from all liability. Most title companies will have a release of earnest money form that only releases the title company from liability, doesn't release the parties. So if we use that form and give the earnest money back to the buyer, the seller hasn't given up any right for future action. And so that's a distinction that we need to make there. Everybody good with that?
Yes.
Okay. Number 5, title issues. We talked about the due diligence of the buyer in the condition of the property. Here. As important, in fact, maybe more important than the condition of property is the title issue. The buyer wants to know he's getting a good title. Buyer wants to know he actually owns his property. He paid $400,000. He gets a warranty deed. So gosh, great. Now, one of the realities of transfer of title, all that's required in Texas for a owner of the property to transfer a title to a buyer is the owner, who is the grantor, completes a warranty deed, signs it, gives it to the buyer. Buyer now owns the property. That's all the sellers do. Now, what happens when the seller does that? All he's doing is he's saying, I want to transfer this, and what I transferred is what I own. We don't know what that is. This is where we get there. We hear ourselves talk about quick claim deeds. And seller says, well, I might own some interest. I might have some interest here. Whatever I have, here it is. You get to have it. And we discover later he didn't own anything. His brother owned it all. and buyer spent all this money and doesn't have good title. So we find ourselves dealing with the commitment, the title commitment, the title issues, and we talked about it here in dealing with paragraph 6. We also talked about it a little bit in paragraph 9. But a really important paragraph in paragraph 6 is paragraph 6B. And this is one of the subparagraphs that there are no boxes. Nothing can be checked off there. And because of that, there's a tendency to pretty much ignore it. And people say, well, that's just a standard policy. Title company's going to get a title commitment. And 90% of the time, it's not a problem. Title company do it, and they send the title commitment to the buyer, and all that's taken care of, and and that's good. But we need to understand a couple of important things. This title commitment timeline is not tied to the effective date of the contract. It's tied to when the title company receives a copy of the contract. That timeline doesn't start until the title company doesn't do any research or anything until they've got the contract, execute contract. So the first thing, look at our timelines in paragraph B, 6B, is tied to that point in time in which the title company receives a copy of the contract. Now, most of the time, it's going to be that same day the parties execute a contract. Sometimes the next day they get it to the title company and the title company gets started in the search and all that. But we need to understand that's a different timeline. And we've got 2 timelines within this contract. One is 20 days, and the other's an additional 15 days are closing, whichever comes first. And if we use that extra 15 days, it's not a full 15 days. It's if it's gonna be done after that first 20 days, has to get to the buyer no later than 3 days prior to closing. So I have a couple of examples here in dealing with this. For example, you've got a contract, and you're dealing with the situation. You're going to have a closing that's 18 days after the title company has a copy of the contract. So it's 18 days. So if I've got a closing, it's going to happen in 18 days. How much time does the seller have to deliver the title commitment? Oh, it's a good thought though, 20 days, because when you look at here, and you say seller authorized title company to deliver title committed buyer, and it talks about a timeline in here. Commitment action document not delivered within specified time. And it talks about the automatic delivery. When we look at this, with 20 days after title company shall furnish the buyer a title company of title insurance, buyer's expense, legible copy, etc., other than standard for an exception. So what they have is 18 days. The 20 days here doesn't get to extend the closing date.
Okay.
So you have 18 days. So that means if you've got a contract, and everybody may be really happy to have a good quick closing, 18 days, 12 days, whatever. They need to coordinate with the title company to make sure the title company can get the title work done in time for that closing in 18 days. Now, my other example here, so you've got a closing that's 25 days after the title company gets a copy of the contract. Well, you've got that first 20 days, and then you've got an automatic 15 days or closing, which comes first, but you have to get it to the buyer 3 days prior to closing. So if you're going to have a closing 25 days, you've done your 20 days, and then to get it 3 days prior to closing, you're going to have 22 days, not 25 days, because you've got to get it to the buyer within 3 days prior to closing. So in a case like that, you have to coordinate with the title company, make sure that's done in 22 days. So your understanding of the timelines and what it requires to go through the process, based on the language in here, you don't get to extend closing dates, you don't get to work through that process. So you need to make sure that you're on top of that. So the title commitment is a very important thing, and no one reads it. No boxes, and there are no blanks. It's just standard. Oh yeah, title company's ordered up, it's done, deal done, no problem. But it's incredibly important because the timelines can totally blow a deal. And remember, even though the contract talks about the seller gives the title company the authority to deliver the title commitment, it's the seller under the contract who's obligated to do it. If the title company doesn't get it done, it's the seller who'll be in default. And your client needs to understand, that's why you need to make sure you're using a title company who, in fact, can get all that done. We've had a couple of out-of-area title companies that didn't get it done in time, and it was the seller who was in trouble as a result. Now, they got to file a claim with the title company because the title company screwed up, but that's a little bit of a different conversation. In some of these out-of-area companies, and it gets to be a little bit of a challenge. So, so all these things that we talked about, the title issues. One, paragraph 6B, we got the commitment, and you got other title issues, you know, dealing with all kinds of things, objections, so forth. But you've got this whole group in there. It's paragraph 6E, 1 through 10, and part of that's 6E2, which deals with manager HOA. But these are all a whole plethora of notices that under certain circumstances that the seller is required to do. In some cases, they've got to do it prior to a contract. The buyer has termination rights based on refusal of them to deliver certain statutory notices. And you know, many properties have, you've got the tax districts, you got the MUDs, the Tidewater. We don't have a lot of Tidewaters up here. If you're down in Galveston, you got a little chance of that. Annexation, you've got a property in a extraterritorial ETJ for city. You have to deal with those issues or have to be disclosed. Public improvement districts, we have a few of those in the area, not very many. And so it's important for you to understand, parties have agreed to do this, and if your seller has anything that deals with these kinds of issues, it's very important for the buyer to have that kind of information because it could really affect on their ownership of the property and could affect the cost that they may have in owning the property. So questions on that, dealing with the title issues? Remember, buyer has two big things they're doing in the due diligence. Condition of the property, title. Do I have a good title? Because I don't care how perfect the property is, if you don't have a good title, you just blew your money. You may not own that property. Yeah, what the title company does is in this title commitment, which has 4 sections, it tells the seller, it tells the buyer, here are the conditions under which we'll issue a title insurance policy. Here are the things that have to be proved out. Number one, we got to make sure these sellers really own it. These are the sellers that homestead or whatever it's owning. And if there's any other people in interest, you see a lot of things that are in there. For example, if a lien has popped up, an IRS lien, something like that, says, and this has to be satisfied and resolved, you may have an estate situation. So in section C of the title commitment, you know, they're saying, yeah, here are all things. Now, in A and B, the title company is saying, here's who owns the property, who has the interest in the property. So this is really giving important information to the buyer. Now, here's one of our challenges. I'm glad you brought the title commitment thing. Because the title company is saying, here's what we know now, here's the condition, here's all that. And here are the condition in which we'll issue a title policy. The big single protection for the buyer is a title insurance policy. You hear these commercials on this title lock thing where it says, hey, people could come in and take your, well, not if you have a title insurance policy. Title company steps in and takes care of that. Because the title company says, based on the information we have, we're going to issue a title insurance policy. We're going to guarantee you a good title. Now, we're not going to guarantee that you don't have debt and things like that, but we're going to guarantee good title. Good and defeasible title is the phrase we use in Texas. So it's very important when the buyer gets a title commitment, and often you'll get it too. I don't want you going through the title commitment and analyzing it. That's a legal thing. What you can do is point out things that could affect title, but not how it affects title. That's a legal opinion. But that it affects title. And that's 2 different distinctions. You know, you see something in the title commitment section C that talks about the fact that there's an heir involved, or there's an estate involved, or there's an IRS lien. You say, you know what? That could affect your title. That could affect how you own the property. However, I don't know how it would, but you need to do some research. First thing you do is talk to the title company. The buyer calls title company and says, tell me about this. I don't understand what this means. How does this affect my ownership of the property? Is this something I want to have coverage of? Because in the title insurance policy, one of the sections that's really important are the standard exceptions. In paragraph 6A, you've got 1 through 9, you've got 9 standard exceptions. Those are automatically in the title insurance policy. Number 8, you can change. We talked about that in more detail in another class. But you can make that change. And the reality is, those standard exceptions, title company saying, will insure title except for you have no coverage on these things. You better prove up these things before you close. Because, and one of the big things, for example, you look on here, dealing with, little things like, for example, there's going to be a lien against the property for the lender that you borrow the money from. Liens created as part of the financing, number 3 there. Title company says, if something happens later and you can't pay your payments, you don't get to file a claim. It's going to affect your title. That's your commitment. You borrowed money from the lender, you let the lender put a lien on your property, that's your issue. Lien, easements that are there, you knew about those before you closed. You got easement problems, don't call us, we can help you. You accepted all those. Those are the things you should have objected to during the term of the contract. So a buyer needs to understand the things that title company covers and doesn't cover. Anytime I look at a policy, title insurance policy, homeowners insurance policy, car insurance, our errors and omissions, one of the first things I go to in our errors and omissions, I look at all the exclusions. I want to know what you're not covering. I want to know what's going on that we have no help with. And that's an important thing as we work through it. So can everybody on the scroll thing, as I'm kind of talking over this week, are you still able to hear me and work through that? I don't want you to, although, I would love to have you if you want to come in, be in the live class. Hi, Daisy. How are you doing?
I'm
I haven't
good.
seen you so long. Have you missed me? I got to see Daisy just last night. She was here in the office.
Yeah,
And
not
so
for
I'm
good
glad
reason.
you made it home and back, and you're at home in the Zoom. So glad to
Yes.
see you there, young lady. Okay.
Thank you. Glad to
Yes,
see you
ma'am.
too.
So how are we doing on the title issues? Property condition, property title, 2 big things for the buyer.
So when the seller or the buyer asks the buyer's agent, what does it mean? You can't tell them what it means. You say, I tell them that. and
Yes.
the attorney-
Okay, so the question is, when the buyer asks you, like something in the title agreement, what does this mean? You can't tell them what it means. What you can say is, here's something that I think affects title, might affect title. I don't know how it might. You need to talk to the title company. Maybe talk to the title company attorney. And if that title company attorney can't help you, call one of the other title company attorneys, Charles Kramer, Kelly Milligan, Don Moore, some of those other people, Brandy Dozier, those other people who can help us going through that. But you've got to make that distinction. You point out, here's something that, based on my experience, can affect your title. I don't know how that is. The fact that here's a seller who died 3 weeks ago, and now the spouse has property, theoretically, that can affect how you can buy the property, how you own the property. I don't know how it will affect it, but it's a legal time. You need to talk to somebody who can advise you, here's what you're dealing with here. You may have to wait and let it go through probate, go through all that process, and that's okay. So our important thing here is we look at the title plan, we look for things that jump out at us. Whoa, $400,000 piece of property, $650,000 IRS lien. Whoa, somebody better check this out. So don't worry about it. We know about it. We're taking care of it. Well, buyer says, okay, I need to know how this can take care of because I don't want to find myself at closing doing all these things I'm doing, spend all this money. And also you say, well, we thought we had it, but we kept buying lotto tickets and it just didn't quite work out. And, those things happen. So we kind of work through that. So we're good with how important the title issue things are. Don't ignore these things because buyers aren't really paying attention to this. Buyers get title commitment, and frankly, they rarely ever read it. You look it over, all you're looking for are big, obvious things that could affect title without explaining how it could affect title. It's a big, major distinction. Everybody good with that?
Yes.
We good? On my Zoom, folks, how are we good with that? Anybody not good with that? Say, wait a minute, Bob. Explain that one more time. Okay, so we go to number 6, and this gets into expenses. There are going to be certain expenses that the seller has and the buyer has to do this transaction. Although we occasionally find ourselves with sellers who say, well, I'll be happy to sell the house, but I don't want to have to pay for it. Or buyers who say, hey, if I can get a freebie here, fine. one of the things that the closest you can get to a no cost to the buyer transaction is a VA transaction, because VA allows the seller to pay everything. Everything. It's called a no deal. The buyer can literally have no down payment, no closing costs, no expenses, nothing. And how they can make the seller pay, they're going to have an option, they may pay the option fee, but they say, seller, we want you to pay for an inspection, we want you to pay for the appraisal, we want you to pay for this. Now that'd have to be a buyer with a very strong negotiating position. There's a line out the door of other buyers not getting away with that. But that's the only possible type of transaction where a buyer can get away with no cost. We don't see that anymore in this environment because we've got the multiple offer situations. But when we look at expenses, we see ourselves primarily dealing with paragraphs 12, 13, and 14. Paragraph 12 really sets forth the expenses for the seller and the expenses for the buyer. And you'll notice when you take a little time and look at those, you'll see that the seller's expenses are fairly minimal. The buyer's expenses are more extensive. If a buyer's doing financing, they've got a big long list. In fact, about 85% of those costs for the buyer are lender related. Whenever you have a transaction that's a cash transaction and the person the title company comes in, it's just a little bitty file. I mean, you don't have all that big stack of lender stuff. And so it's a much easier, simpler transaction. But, the things that the seller's expenses are expenses you'd expect. They've got to pay for a lien that you're going to release, tax process, things like that. And then under the seller's expenses, you've got in 12A1B, if the seller's going to pay some money to the buyer, seller concessions, we address that in there. And then we see in number 2, where the buyer's expenses are there. And if there's anything in the contract they agree to and turns out the numbers are different, and then talk about things like maintenance fees, assessment, whatever, then it gives the parties right to terminate the contract. It's kind of that, little protection there, get to a certain level and say, hey, it's not what we planned on. We either need to make some change or do something there. We also about paragraph 13, the proration. Everybody needs to know what's going to happen at closing. Sellers are going to have to pay their existing loan off, and their interest on that existing loan runs through the day of closing. The buyer gets a new loan, and his interest starts on the day of closing. So on the day of closing, from a finance standpoint, both parties pay their respective financing fees. Then it talks about other things, proration, the taxes, if there are any HO fees, things like that. So those are all cost. Now, paragraph 14 is an interesting thing. You could have an expense. Because if you've got a situation where there's a casualty loss, you have a windstorm, you have fire, rain, hail damage, things like that, tornado comes, house gone. We need to know, what's the expense? Who's required to pay for what? Who has to do what? Well, that's casualty loss. Paragraph 14 says, seller's responsible. Seller's got to do this as soon as possible, certainly prior to closing. Now, there are circumstances when seller just can't do it prior to closing. It's just not possible. The physical reality is not that. So it gives the buyer certain choices. The buyer can terminate the contract, can turn some money back. Buyer can extend the closing date. Buyer and seller can mutually extend it, of course, at any time. Or buyer say, okay, we've got an insurance company and we want you to transfer the proceeds of that, credit for the deductibles, and we want to have that. So paragraph 14 has got a possible expense situation based on some circumstance. As you know, that's kind of what they've agreed to there. Zoom questions? We good on that so far, where we're talking about the settlement and expenses? And Brian says, yes, Bob, I fully understand that.
Bob, I think I got that. Thank you. Thanks,
which is a good affirmation and scary at the same time. What happened?
Absolutely.
Why did I lose it? Did I lose you out there too?
Well, yes. Go back up. There you go.
Mm-hmm. Okay.
A question.
Yes, question.
And a question on the assignment from the insurance company. What would you need to have as a listing agent from the insurance company, or does title take care of that? How does that work when you're going to close?
Okay. If you're going to have where's the rest of it? The rest of it's not even there. It doesn't happen very often. Insurance companies are generally not doing that. Sometimes if you got both parties with the same insurance company, then they're more likely to do that. Somehow that stuff just didn't get hoppy. Wow. But you leave the parties to coordinate that with the insurance company. You're not involved. It's just they agree to amend the contract and address the issue that's brought up in paragraph 14. Hopefully everybody has their form in front of them, because as I tried to share it up here, stuff after number 6 doesn't show up. I thought I had copied it all, but evidently not. Okay, so number 7, hopefully you've got the paperwork in front of you. So number 7 deals with closing and possession. And these two work in tandem. Closing, you have a date. So in paragraph 9A, you'll actually have a date or some formula to arrive at a date. For example, if you're dealing with a backup contract, you're going to tie a closing in a backup contract to an amendment date, to the fact that you have a closing date that you can't say, because if your backup contract becomes the first contract 2 days prior to the closing date of the first contract, you won't be able to get all your stuff done in 2 days. You probably need another 20 days. So what you're going to have is a formula in paragraph 9A, so that the closing date, it may be 25 days after the amended effective date. And the amended effective date is defined in the backup contract addendum. And so you would address it there. So closing, you've got a date. Possession is an event. You don't have a date for possession. And it's very important you look at 2 of these. You've really got 2 choices in possession: closing and funding, and that typically is the experience in any vacant properties. Certainly probably where the seller's getting ready to move, already moved. Then closing and funding is when you're going to deal with possession. The other is according to a temporary residential lease. Key there is you may have a possession that's transferred at a different time than title is transferred. In the typical scenario where we have a seller's temporary residential lease and the seller's going to stay in the property for a week after closing, the reality is, in that situation, according to the terms of the lease, even though the seller no longer owns the property, he's still responsible for it. Because until possession is delivered to the buyer, seller is still responsible for the property. And that's why we have in bold print in paragraph 10 and also in the seller's temporary release, talk to your insurance agent, find out what your coverage is. Because if something happens in that week, the seller's in the house and the tornado comes through and blows the house away, whose insurance is responsible? We don't know. That's why they've got to talk to somebody and find out, who's covering it, who's not covering it, how we work through that. It's very, very important in dealing with that, because in many ways, the transfer of possession is more important than a transfer of title because of who's responsible for the condition of the property. That's why one of our absolutes, an absolute, remember what that is in our office. An absolute is one of these crazy things that Bob says, you have to do this every time. No exceptions, every time. Now, here's what Bob understands that means. We're all human. And even though you know you've got to do it every time, if you know it's absolute, that means you'll do it most of the time. Because things happen. You get real busy, it's a Friday night, and somehow you just don't get it. But one of the absolutes is if you represent, I don't care either side, if there's a seller's temporary residential lease, you have to give written notice to your client. They have to talk to your insurance agent. If something happens because they haven't talked to your insurance agent, we need to have that documentation. We need to be able to show, yes, here's what, we told you to do this. You're an idiot, you didn't do it. We told you to do it. And here's the documentation where we told you to do it. So don't fuss at us. We have no control over that. Here's where it's at. Bold print paragraph 10. bold print, it's in the lease. It's all right there. So you've got to be able to do that. Remind me who that is. Oh, that's Lindsay.
Yeah, nice.
So working through this, that's an absolute. And this is what points out how important possession is, the title. The responsibility condition of property is not so much who owns it as to who has possession of it. And that's controlled by paragraph 10. And it's really important for the parties to understand that distinction as they work through that. Absolutely key. So please, one of my about 6 absolutes in the transaction, please, if you'll just get into the habit, say, oh gosh, here's another one of Bob's absolutes. I guess I got to do this one.
Yep.
If you'll just do that, it'll protect you. It'll make it better. And the big override absolute for me is documentation, documentation, documentation. When you say something important to a client, I want it followed up in an email. So later say, whoa, 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 you never told me that. Yeah, I did. And here's where you acknowledge the email. Oh, yeah, okay. I guess I remember that now. Okay, so we good with the distinction, how important it is for us to understand closing and possession? Everybody good with that?
I have a question.
Yes, ma'am. Question.
On the absolute,
Yeah.
is it prudent also, besides giving written notice to our client, to copy the other side's agent?
Yeah, so the question is, in addition to advising our client, do we also advise the agent on the other side? I would think that's good. You want to be careful how you do it, because they want to feel like you're lecturing them, say, well, why do they tell me this? Everybody knows you're supposed to do that. So you might say something general like, oh, I just want you to know that I have advised my client to talk to your insurance agent, as I'm sure you've told your client, because we see that in the contract as a very important thing, because it's important. We don't want to find ourselves in a situation where something happens and our buyer has talked to your insurance agent. You're going to say, well, you got no coverage for that. And so we look at the other side and they say, oh, we meant to check on that. We didn't. And now we've got a problem. So it was much help for our client to know the other side has done it too. Just be careful how you go through and advise them of that, because you could kind of get them a little bit off kilter there as you work through it.
Just a courtesy copy to let them know that we.
Yeah, what you're doing is, yeah, it's a good thing to say, we've advised our client because, possession's not going to be the transfer of title, and your seller's going to stay in for a week after closing. And we've told our buyer to talk to your insurance agent, as I'm sure you've also told your seller, because we know that's really important for both sides.
Right.
And so you're doing it. So you trying to write that down?
Yes.
She's trying to. All right. So, okay. Does that make sense? You understand the concept of it? So you see where it's in the bold print, paragraph 10? Okay. And it's also in paragraph 17 of the lease itself. So, but that becomes, and there's an interesting thing. When I served on the Berkeley Lottery Committee, there were several things in the contract that I thought were so important that it needs to be in bold print. One of them was in paragraph 2 in 2B, dealing with improvements. With the following items, which deals with, and I said, hey, that's pretty important. That's an umbrella statement. We're talking about things that are, built in, permanently installed, bold print. So, and I think it is an important thing. There's an interesting irony though. Sometimes people go right past bold. I don't know what the human nature factor is, but you'll look down at it and oh yeah, now I see it. Yeah, I was just looking at the consultant. That's just one of those notice things. Sometimes until you point it out to them, they don't really look at it and say, yeah, this is kind of one of those things that you may have to make sure you kind of do that, work through it, make sure you talk to your insurance agent. And that's just so critical, because we have this every year. We have things that happen, and not just always weather kind of things, but people damage property. Things happen, and tenant is negligent, things like that. The seller slashed in it, and so it's really important that we work through that. So everybody so far good with that? Okay. Now Number 8, I've got a bunch of miscellaneous topics. And these are a bunch of the paragraphs that we have on our little thing here. Paragraph 15, the default paragraph. The overriding thing we want to understand about the default paragraph, that's a legal issue. You don't ever make the statement, oh yeah, a seller didn't do that, they're in default. Even though that might clearly be the language, what it says in the contract. And in paragraph 15, it says, you know, if one party doesn't do it, the other party, non-defaulting party, you know. For example, it starts off, paragraph 15, if buyer fails to comply with his contract, buyer will be in default. Well, I don't know what it means that fails to comply. That's open to interpretation. What do you mean you think I had to do that? Where does it say I have to do that? Oh, I see it now. Okay, fine. It's open to interpretation. You know, a buyer may say to a seller, you're in default because you did not give us receipts for all those repairs. Well, it's not in the contract. There's no requirement in the contract for receipts for repairs. It'd have to be in a repair amendment. Parties would have to agree to do it. And so they need to agree, here's what our certain performances are, here's what's required. So the key with the default is simply let our client know, if you think the other side is in default because they do whatever, you need to talk to an attorney. It's a legal issue. It's not an agent issue. We'll be happy to support you with whatever documents we have in our possession we have helped to you. If we've got a buyer who thinks the other side is in default, we'll take action against them. We've got our 6 steps of a demand procedure that you can provide to them, and they can use that as a kind of a track to run on. But otherwise, you know, work through that. So in dealing with paragraph 15, that's a legal issue. And if they're all excited about that, let them deal with it. Paragraph 16 is mediation. Understand what this requires the people to do and not required. Texas' position in mediation is really, it encourages the parties who've got a dispute to mediate. It does not take away either party's rights. See the last sentence in paragraph 16, mediation. This paragraph does not preclude a party from seeking equitable relief from a court of common jurisdiction. If they need to go to court, they can do it. This paragraph does not require them to go to mediation. Where it talks about, you know, any dispute between seller and buyer related to, which is not, you know, see through a formal dedicate, will be submitted to, doesn't say shall be, doesn't say has to be, doesn't say must. It should be, you know, you ought to do this, you ought to go. But if they both say no, we're not going to waste time with that. Now, the reality is, and what the clients need to understand, particularly if a lawsuit is at a level that it's going to involve a lawsuit in a district court, which is a lawsuit that requires attorneys. Virtually all of the district courts, certainly the ones in Collin County, the judge is not going to hear the case until the parties have gone to mediation. So we're not going to waste court time until you guys have at least tried to work things out. So the judge is going to say, here's a court-ordered mediation. So because of that, they ought to go ahead and voluntarily agree to mediate, because the way you mediate voluntarily is different than a court-ordered mediation. And so you want to stay more in control by a voluntary mediation and going through that process than a court-ordered. So it'd be to their advantage to go ahead and do that. Miscellaneous in paragraph 17 deals with attorney's fees, and it talks about prevailing party was the party that, you know, that wins a case. They have a right to reasonable attorney's fees, all costs of proceedings. Real world, what you need to know, even though the attorneys will send their bill to the judge, the absolute decision making is the judge. The judge says, okay, I see you've got a bill for $9,000 legal fees. I think it's excessive. I think I'll give you $5,000. Judge has total control on how much the attorney's fees are and how much all the reasonable costs are. We're generally not involved in this unless we go through a process because it talks about buyer, seller, listing broker, other broker. you know, that they have rights. So if we have an attorney and we've gone through the process and we've expended money, legal fees, and we feel like we need to have some reimbursement for that, we get to file. It's going to come down to what the judge thinks. And I will tell you, rarely does a judge agree with the attorney's bills. Because he used to be an attorney too. And remember how he used to bill. And I thought about that case. Whoop, there's another 15 minutes. $100, pop and go. So we don't usually find ourselves involved a lot with 17. Now, 18, paragraph 18 is our escrow paragraph. Really important paragraph, and addresses two scenarios. One, we have a closing. Two, we don't have a closing. And frankly, that's total right there. We're either going to close or we're not going to close. Sometimes we're going to close, but it's not what we thought and when we thought, but eventually we close. We're either going to do it or not. And one of the things it talks about, paragraph 18.8, it talks about, for example, how the earnest money is applied. I go through the process. And it also talks here in 18b, it talks about that if for example, we don't close and the buyer gets the earnest money back or the seller gets the earnest money, the title company can look at any costs that were incurred on the terms of the contract by that party who receives the earnest money and subtract that before they give them the earnest money back. For example, survey cost, or a typical example. Survey had to be paid for, buyer was going to pay for it, had a survey done, cost of survey is there, buyer getting the earnest money back, so he gets $5,000 back, and there's $400 for a survey. Title company has a right to pull that $400 out because they've already paid for the survey. Say, you know, we're going to give you the earnest money, you're going to get $4,600 because we had to pay for the survey. So any costs that were incurred in the terms of the contract can be removed from the earnest that you're going to get. We also have a demand paragraph here that if one party is going to demand the earnest money of the other party, you got a 15-day time frame, you got a process here. So technically, the title company, if they don't receive a written objection from the other side, can, after 15 days, release earnest money with just one set of signatures under the paragraph 18D scenario. We good with that?
Yes.
Okay. Paragraph 19. Talks about some things that survive closing, you know, certain promises, certain warranties, things like that, representations. But one of the things that often gets missed in paragraph 19 is that the parties do agree. And sometimes you'll get buyers who get all nose out of joint and say, we got a contract. You know what they did last weekend? Had an open house on our property. It's not your property. You know, are they not committed to sell? They're having an open house. They're still looking for other buyers. What's going on here? Gosh, you know, what kind of people are these? Well, buyer, you agreed to that in paragraph 19. In paragraph 19, seller may continue to show the property, receive, negotiate, and accept backup offers. If the buyer said, if I'm going to pay option fee, earnest money, inspections, appraisal, I want you committed. I don't want you to show the property anymore. I don't want you to entertain any backups. Now that's attorney prepared language. But a buyer could do that. A buyer could say, hey, that's part of the negotiation contract. I want you committed to me as much as I'm committed to you. If you don't do that, seller can keep holding open houses, entertain backups, go through that process. They get to do that. So that's an important part as you work through that. And this kind of relates a little bit to paragraph B of the sale of the property addendum, because the seller has that right whether you agree to it anywhere else or not. It's just there. Now, in paragraph 20, this is the foreign person thing we're dealing with. Notice the title for paragraph 20, federal tax requirement. And what this references to is a foreign person as defined by Internal Revenue Service rules. It doesn't tell us what those rules are. It doesn't even reference to the section of the code, but it says, here's what we've got. We've got a foreign person here as the IRS defines it. Then we've got certain things involved. It doesn't have any amount in here. It doesn't say it was 10% or 50% of the sales price. Tells us all things if you're going to buy for a homestead or if it's a homestead, doesn't apply. If it's less than 300,000, it doesn't apply. None of that's there, but it's in the IRS code. And this is a real challenge for us, the foreign person thing, because there are several big things that come out of this. Because the IRS rule that we're saying, when you look at the situation, where it says, if the seller is a foreign person or fails to deliver an affidavit or certificate of non-foreign status, that to buyer that seller is not a foreign, they do that at closing. All sellers at closing will have to sign an affidavit saying they're not a foreign person. And even if they lie about it, the title company and the buyer can rely on that statement, that affidavit. So if they fail to do that, buyer shall withhold from sales proceeds an amount sufficient to comply with applicable tax law, which whatever that might be, we don't know. So a buyer has a serious potential responsibility here. And it just tells us about that without really defining anything. So as we look at this, we understand that, and I asked a question on the 7th page here at the top there, and I say, okay, so what's the most important thing an action should be taken for a transaction that involves a foreign person? What do you need to make sure you do? Let's say you got the buyer, and we now have information the seller's a foreign person. We'll talk in a second about how we discover that, how we know it or don't know it. The most important thing, you've got to know the title company's involvement in the transaction relating to the IRS rules relating to a foreign person. Some title companies are total hands-off. Don't bother us, not our problem. It's a problem between the buyer and the seller. Deal with it, whatever. We're not going to touch it at all. We're going to have the affidavit at closing. Seller's got to sign the affidavit. We're not going to withhold the proceeds. We're not going to give the buyer the form. We're going to show them how to fill it out. We're not doing anything. And a number of otherwise good title companies take that position. Not little rinky-dink small ones, but some good sized ones. Some title companies take a very serious position and are incredibly helpful. Republic Title is a good example. Very involved, and they help you right through the process. If it's one of those things where proceeds have to be withheld, they've got the form, they'll withdraw, they'll pull the money, they'll send it to the IRS on behalf of the buyer. I mean, they're very helpful. Some other good title companies do that in Chicago.
Which title company?
Republic Title in Chicago also is very close to the same thing, unless you get some of their fee attorney offices. Question? Pardon me?
No, fair.
You know what? I don't know what Fairtech, and they're a really good title company. I don't know their particular policy, but it's a great question because here's the key. If you know you've got a foreign person, you've got to ask the title company, tell us, what do you do? What's your policy on this? What can we expect from you? Now, here's our challenge. I have a question over here. We good? Here's our challenge. How do we know if the seller is a foreign person? It's not in the seller's disclosure notice. When the title company sends out and gets information, one of the questions that you may have that information there. Sometimes you technically don't know until closing, but is it important to your buyer that you know whether or not there's some big surprise you have at closing? We've got a foreign seller. You can't presume because they've got an accent or a funny way to spell their name that they're a foreign person. Can't presume that. Right, Brian? Okay. So you get the buyer, how are you going to find out? Are you going to ask the listing agent, hey, we got to meet your seller at the house and you look pretty foreign to me. I just wanted to confirm that because you got a real problem there. Here's the only way a buyer's agent can ask about a foreign seller. Every single listing agent on every single property the buyer's interested in, they ask. Every one. If you pick and choose, you're discriminating. You have to do it on every one. Now, we have a thing where some listing agents say, okay, I think I'll put it in special, I'll put it in MLS, priority marks. I have a foreign seller, but don't worry about it. He's taking care of the taxes or whatever. Well, the risk there, number one, you're going to have permission of the seller to do that. And seller may say, whoa, I think if we do that, we're going to run some buyers off because you won't understand what we're talking about. So chances are you won't have permission of the seller to do that. But you need to have that conversation with the seller in the listing agreement in the Texas Real Listing Agreement, we ask that question. If you're a foreign seller or not, foreign investor, foreign person, as it talks about paragraph 20. And that helps us make sure our seller is prepared for moving towards closing. Because if there's going to be some requirement to withhold, sometimes there's not enough equity in the property to cover the amount of that withholding. It can create a real problem at closing.
So your recommendation would be to ask every time, do you ask before the showing? Or do you ask if
Well, here's the thing.
the buyer is really interested?
If you're going to ask, yeah, you need to kind of have a conversation with your buyer. And remember one of my great phrases, every transaction you do changes what you do in the next transaction. If you had this happen to you a couple of times and you just had a buyer went through it, hecking back because there's a foreign person and all kinds of withholding and tax, all that kind of stuff, then you're finding yourself dealing with, well, you know what? This point forward, every buyer I get, I'm going to talk to them and say, here's an issue. Maybe we should want to make sure that we don't have a big surprise at closing. So every property that you have an interest in, that I'm pulling up information for you, and I'm going to show you whatever. If there's an interest there, buyer on your behalf, with your instruction, I'll ask every one of those listing agents if, in fact, the seller is a foreign person, as defined by the IRS rules. I'll ask every one of them. Now, some of the sellers, some of the listing agents won't tell you. So, whoa, that doesn't even sound right. I don't think we can talk about that. I think you're discriminating when you start talking to me about, well, I understand. So you may not get a lot of cooperation. Most listing agents say, well, yeah, because it's in our listing agreement, and they did say they're not. So I think we're fine. Our problem gets to be where we begin to try to define U.S. citizens or not citizens, or green cards or not green cards. Good title companies have all that down and they understand that. So sometimes a quick conversation with them. But based on your experiences with transaction where you had a problem with this, had an issue, you'll find yourself being a little more diligent. I cannot overemphasize how important it is that you don't discriminate. You don't do it on a
Piecemeal.
random basis.
Yeah.
It's got to be consistent. You have good documentation. Here's our policy. Here's what we've done. Well, a buyer said they were very concerned about this. They want to know about this. And you know, because it's so, we had an agent, good agent, that said, yeah, look at the name. You're telling me they're not foreign? Come on, no, so you can't presume that. You can't look at somebody's name and presume that they're a foreign person. I mean, that may be a fifth generation American. They've just kept that good name all that time. And, you know, not everybody can have a good common name like Baker. I mean, you know, some people have 15 different consonants in their name. Doesn't mean they're a foreign person. Can't presume that. Because, I mean, I will take, because we have more and more foreign persons buying and selling real estate in the country, and certainly have it in our area. And so this is an issue. And I think the most important part of this is if you've got title companies you do a lot of business with, talk to them about this. What are your policies? How do you handle this? You know, what's your situation as you work through it? Because it's important. It's just one of those kind of things. Really have to be able to deal with that. Now, paragraph 21. Notices. Who should go in this paragraph? Oh, question. I have a question over here. Yes, Brian.
A quick question before we move
Yes,
to the
sir.
next section, and that is with foreign person, is it adequate enough to reach out to the listing agent once you're under contract to ask if there are any tax implications that the buyer needs to be aware of? Is that adequate?
Okay, reach out and ask what?
Ask the listing agent if there are any tax implications that the buyer needs to be aware of at closing.
That's an interesting way to get around the question. I think you probably could ask something like that as long as it didn't imply in some way. Did everybody kind of hear his question? He says, once you're in a contract, is it okay to ask the listing agent if there are any tax implications that the buyer should be aware of at closing? One, in the sales disclosure notice, they would disclose that. Second, the title commitment would give that information. So maybe if you wait till you get the title commitment and you have that information, and so, that kind of thing. Maybe do it then. If you could probably have a policy, if you're not, prior to getting into a contract, if you're not already asking those questions of every listing agent, if your policy is based on your buyer's instruction, that you only have that conversation with a listing agent in a contract, but every contract your buyers are in, and you could even kind of maybe couch that question with the listing agent saying, I just want you to know that anytime I've got any buyer in a contract, if we don't have the information otherwise, I always ask if this seller is, excuse me, is a foreign person as defined by the IRS, which may create, tax implications at closing. And I think you would emphasize, I ask this of every listing agent on every contract, every buyer I have. That way they know it's consistent as you're working through it. And then of course, you're going to follow up that conversation with an email. So there's an acknowledgement of what you've just done. Does that kind of answer the question, Brian?
It does. I didn't know if I
asking there. Makes sense. Is that good for you, Brian?
Yeah, I didn't know if I could include that question about a foreign person, so thanks for that clarification.
Yeah, because you're working through getting clarification.
Would this be something that an agent might want to include as part of their buyer's rep agreement, where they notify their buyer that this is going to be their practice?
Yeah, and special provisions. So the question becomes, is something you might want to put in the buyer rep agreement? And certainly you could do that in the special provisions of your buyer rep agreement. Based on your experiences, you could say to every buyer that you have in a buyer rep agreement, this is our policy and this is how we go through the process to inquire on all properties you're interested in about the foreign purchase. This could be something, and you're doing this because we've had an experience that, sometimes this is a complication shows up at closing and we don't want any big surprises at closing. There's only one surprise we're ever okay with at closing. We get more money than we thought we were going to get. And we're okay with it. We can live with that. So otherwise, no deal. Okay, so back to paragraph 21, which you're trying to avoid. I understand that. It's a very complicated paragraph. Who should go in paragraph 21 and why?
Our email address.
Yeah, our agent's email at your email address. Now, using transaction coordinator like Marcia, put CC and put their information in there. Now, your client, everybody says our client has to be there. That's where the title company gets the information. Well, there are other ways to get the title company information. And probably you're going to have your client there. You don't have to put their name because we defined that in paragraph 1. You put your email address. Don't do it without their permission. They may not want everybody and his brother to have their contact information, even their email. Because when we have a transaction that doesn't close and people are going to sue each other, and the buyer says, okay, I need the seller's contact information. What's their email? Well, if it's already there in paragraph 21, they've got it. All of a sudden, the seller says, man, I wish they didn't have that. They're suing me now and they've got my information. So talk to your client. Say, okay, I'll put your information in here as long as you give me permission to, and you understand the risk.
In writing.
Yeah, you can follow that up with an email. And so you say, yeah, here's the deal. Otherwise, that last line there is your email address. If you ever put a phone number in here, it would be yours. Don't ever put a client's phone number in here. No reason for, the number of people who see this contract is huge. No reason for all those people to have a phone number for your client. Just don't do it. And I know we got new technology out there. I don't know what faxes are. Maybe that's a new technology, not up on it yet. Whatever it is, I don't know. If you got something that fits that, I'll get back. Everybody good with 21? Any questions on 21? Okay. 22. Paragraph 22, the title is not addendums. The title is agreement of parties. We've got a contract, and within the 24 paragraphs, you've got all kinds of things that the parties have agreed to, all kinds of performances. Well, not everything that we want to deal with is in the contract itself. And the Broker-Laurie Committee established a concept several versions back, and they literally changed up the contracts dramatically. We used to have one contract, a separate contract for financing, and a separate contract for cash. And then we realized, you know what? We could address that in addendums. We could just have that one contract form and have paragraphs that reference out to a financing addendum or a sale of other property, because we can just do that with all the addendums. And we went from, back in the old days, which is not necessarily good for everybody, we didn't have all these boxes to check off. We had blanks. And you had to write in, literally write in the addendum. Some of these addendums are really long, and it's a real challenge. Now we just got the boxes. You just check it off, and there it is. Now, you may have exhibits. You may have other addendums in dealing with issues. You may have an exhibit that has a legal description, has other names of the sellers or buyers or whatever. All of this is an integral part of the contract of what the parties have agreed to. And any addendums or exhibits here has to go to everybody. Parties, title companies, lenders, everybody. And occasionally we have lenders say, whoa, 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 we don't want to see that. Well, it's an integral part of the contract. Is there anything else you want to see? How about paragraph 14? You want to take paragraph 14? You know, it's all there. So we need to make sure everybody gets that. Questions on 22? Okay, 23. And it's 23 tends to be a fairly misunderstood paragraph that everybody says, yeah, I know exactly what we're doing there. That's the option period. Pay an option period, got an option period, 10 days, whatever. We can do all our inspections and we do all then. That's the deal done. Well, first of all, paragraph 23 is entirely voluntary. No requirement to have it. In fact, if you leave it blank, it's automatically gone. Now, if we don't do paragraph 23, we don't have an option period, don't have an option fee, all that is affected in the entire contract is the provisions of paragraph 23. Doesn't do anything to anything else in the contract. No other part of the contract is affected. This is a sole situation. The buyer has simply lost their unrestricted right to terminate under paragraph 23, and that's all that's happened. The buyer may have other rights. I mean, a sophisticated buyer who's buying a house in a metro HOA, in which they've got a free option period for however long it takes the seller to get them the, HOA information, a free option period. The buyer may say, sophisticated buyer, Class A buyer, push, 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 push. Why am I paying $250 for 10 days? It's going to take them at least that much time to give me the HOA, so I got that for free already. Why am I paying for that? Well, and there may be a reason to pay for it. One, it's what's expected. It's what is going to improve the negotiating environment. So if you've got to negotiate for a lot of repairs, that may be a good thing to do. But it's entirely voluntary. If you don't do this, all that's affected is this paragraph. That's it. Doesn't change any other rights termination. And paragraph 23 does not in any way relate to paragraph 7A, which deals with our inspections and our access. We have agents out there who say, well, you got another 2 days in your option period. You better get those inspections done, because after those 2 days, you can't even do any more inspections. You got to get those done because we got to negotiate repairs. We can only do that during the option period. Absolutely not correct. There is nothing in paragraph 7A and paragraph 23 that relate to you. But that's the norm. That's the expectation in the marketplace. That's when people expect to do certain things to such a degree that we've got brokers for some really major companies out there say, well, Bob, the option period was over yesterday and your buyer's still trying to negotiate. Well, Mr. Lou, my buyer can try to negotiate all the way to closing. So I don't have to do anything, but there's no limitation on that. And it gets to be a real challenge. So we need to understand what's going on in paragraph 23. And that all is affected is dealing with that. Does that make some kind of good sense? And I realize I referenced to 10 topics, but I really only went through 8. For some reason, I'll have to look at my stuff again. See if I missed anything else that just doesn't show up there. So here's the concept. In a summary here, I talk about that we have to be aware of all the variables. We got to be aware of the concepts that are in the contract the parties agree to, and what the buyer sellers are doing. Buyers got big due diligence, condition, inspection, value, all those kinds of things. And the ultimate thing for a seller typically, seller said, how much money am I going to get and when am I going to get it? That's what the seller really wants to know. Oh, you're going to pay me $400,000? That's good. When do I get it? When do I get the money? And when do I have to move? You know, what's going on? So there's some of the big questions. Now, the seller underneath that all said, okay, you're going to pay me $400,000. Where are you going to get it? Where's the money coming from? And so they go through all that. Buyer says, okay, I'm willing to pay $400,000, but let's see what kind of condition it's in. Let's see what's kind of going on there. Let's see if we got some real title problems here. You know, maybe there's maybe you don't really own the property. And I make this statement sometimes in kind of joking, but it's real because we've had it happen. When someone is selling their real estate, we kind of need to ask them, do you own it? Why do you think you own it? Why do you think you have the right to sell it? Well, we've been living here for 15 years. We've been making payments every month. It's our property. Well, you know what? We just discovered it belongs to your aunt and uncle who bought it for you, and you're paying them. And you don't own it. They own it. In fact, even worse, it's a contract for deed. And the contract for deed tells you whether or not you have the ability to sell the property or not. So there are people out there who think they own the property and they don't. You know, the last surviving father or mother or whatever passed away, and the daughter's been living there the last 5 years, taking care of their ailing parents. And they always say, well, you get the house, once we die, you get the house, it's your house. Well, with no will, she's got 5 brothers and sisters who all think they get the house. She may not really own it. You got to go through a process in Texas to determine who really does. The court has to say they own it, they have a right to sell it, they have a right to proceed. That's something that has to be done going through the process. You kind of work through that. Is this helpful to you? Just give you some good concepts?
Yes.
Yes, ma'am. Question.
Quick question though, is that something that's universal in the United States or just Texas?
What? What universal?
Does that person that's been living there for X number of years, and they don't own the property?
Yeah, just living in a property may give you certain rights. You know, there are rights of adverse possession that sometimes go along with possessing a property. And that's a legal issue that's going to require attorneys to define it. And there are a lot of variables and there are timelines on that. That's a little bit in the whole thing where people talk about squatters and people gaining rights to property. You see this in vacation homes where the people aren't there for, and they may go years before they go back and visit the mountain home again. Somebody's been living there for years, you know, thinking they own it now. So yeah, that does happen. And there are people who, there are fraudulent title issues out there. One of the challenges with title companies, one of the claims they have to sometimes deal with is the fact that the person who came to closing and signed the closing papers and signed the warranty deed and got the money and left the country never owned the property. It was all of it was fraudulent documents. I tell the story. I've got a friend who was originally from Florida, and his family was acquainted with the family in Florida. You know what I mean by the family, Godfather and all that kind of stuff. And there were these guys who discovered that many of the people up in New York, places like that, bought these mansions down in the Miami Fort Lauderdale property, but they didn't visit them in a long time. You know, there's maybe like 3, 4, 5 months a year they were there, and all the rest of it, nobody. So what they began to do, this guy was scamming everybody, and what he would do is he would create fraudulent documents and begin to sell off properties. Just a lot of people didn't know you really were the owner or not the owner, whatever. And the FBI was going through the process of investigating, and he had done this to several properties, and he was really making well. And then all of a sudden, he wasn't doing it anymore. The FBI was checking back, and they found out the last time he did it was a property owned by the family. Well, I think the family took care of that.
Solved it on their own.
Solved that little problem. Didn't have to take him to court or anything. We don't think you're gonna do this anymore. Go swim with the fishes. Okay, guys, thank you very much for being here. Any last minute questions we have? I appreciate you being here. We see we got some good participants there. Okay, work through it. Thank our people here in live classes. Thank my daughter Julie for helping me work through all this. I'm a host here, so I can sign in or sign out, and she'll show me how we do that. But thank you very much. And we got an advanced class towards the end of the month. It's going to cover a lot of multiple offer and other things. Everybody have a great weekend and be safe.